Okay, good morning, everyone. It is 11:30 on the dot. I know we still have some people joining us, but I will go ahead and kick us off with a few little announcements as we get started here and before we turn it over to our friends at Underwood Law Firm. Underwood will be walking us through some of the more pressing legal issues that school districts are facing as we head back to school this fall. This webinar is being recorded and we will post it on our website for those who could not join us to be able to watch it at a later time. We'll also be live tweeting, so follow us at Fast Growth Texas, and if you have things to add to that conversation, we would love for you to join us there or in the chat box. We will be monitoring the chat box, and later in the presentation, we'll have some time for some questions. We do intend to continue these webinars. This is the first of the school year. It's kind of our adaptation to our traditional regional lunch and learns. So we will be delivering these virtually for the foreseeable future and have a lot of great information to share, and we'll be working with our partners to do that. Some of those topics, we're looking at finalizing those now and some of those dates as well, but as we head into a legislative year, we can expect some legislative updates, election updates, and more along those lines. But thank you so much today to our valued partner, College Board. They're sponsoring today's events. Jill Schott is with us, and she is going to share some great information at the end of this about what College Board is doing to prepare for the upcoming year, including some AP resources and PSAT updates. So thank you again to them for everything they do in partnership with Fast Growth, as well as all of our Texas public schools. Please stay on, and we look forward to hearing more from Jill at the end. A few quick announcements. Of course, you have probably seen by now that Fast Growth made an exciting announcement that Dr. Greg Smith of Clear Creek ISD will be taking the helm of Fast Growth as Executive Director in January. He is very committed and prioritizing his work at Clear Creek ISD through the end of this semester. So we look forward to him joining us in January and wish him well as he continues his important work in Clear Creek ISD until then. We are working to update our membership database at this time, so please, in our most recent newsletter, there's a link to update your membership contact information and contacts, so we encourage you to do that. And don't forget about our COVID-19 resource page. We have a lot of great updates on there. We are thankful to all of our partners who are sharing some great resources there, and hope that you will continue to reach out and utilize that page as we continue to post more and work with our partners on that. So let's move into our presentation with Underwood Law. We have with us today Andrew Tatgenhorst, who focuses practice on representation of school districts and other educational entities in all aspects of school law, with a particular emphasis on special education and disability law. Prior to representing school districts, Andrew was a legal editor with LRP Publications, the leading national resource for special education conferences, trainings, and publications. And in addition to his work with Texas Public Schools, Andrew also serves as general counsel to several standalone library districts. Colby Nichols with Underwood Law Firm is also on the call. He is a member of the Fast Growth Lobby team and will be joining us today. Andrew's really leading the presentation, but will be joining us today for anything he might have to add. He began his career as an aide to former House member and public education chairman Jimmy Don Aycock, and later joined the Region 6 Education Service Center. Colby's practice is focused on general school law, including but not limited to elections, purchasing, construction, student issues, and employment. Colby also focuses on the representation of various education-related clients during the legislative process. We are thankful to have them today, and always thankful to have Underwood Law Firm as a member of the Fast Growth team. So Andrew, I will turn it over to you.
Thank you so much, Kate. And yeah, we're very happy to be here. And you said my name perfectly. That was great. You'd be a little intimidating, right? Tatgenhorst.
Yes.
but you nailed it. As Kate mentioned, I'm an attorney here with the Underwood Law Firm out of Austin. Colby and I are in the Austin office, and we're both school lawyers, and Colby's also a lobbyist, as you all know, with Fast Growth. I'm going to try to share my screen now, and hopefully this will work. So everyone can see that, I hope. You'll notice I made the title a little longer. I didn't think legal issues in COVID-19 was sufficiently long enough. I'm a lawyer after all, right? So I went with legal issues in returning to school in the COVID-19 pandemic. And I didn't do that just because I'm a lawyer and I wanted to make it longer. I did it because it's the sort of the legal issues we're dealing with today. This is probably going to evolve over time, and we're going to see more and more legal issues come up as students come back to school, both virtually and in the physical environment. And today we're going to talk about some of those issues that have come up, right? Some of the issues that Colby and I have been dealing with on a day-to-day basis that we've seen come up as students return. And we're going to really do that from a 30,000-foot view. We're not going to get too in-depth in any issues and just give you some practical tips and advice on really, how to spot issues and when you need to look further at certain things. Colby, do you have anything to add to that overall introduction?
No, I think that was a great summary leading up. As always with any Zoom, feel free to ask questions in the chat. We'll try to get to them at the end. I believe Kate's going to read some of those questions off. So if you have questions throughout the presentation, feel free to put them in the chat.
So we'll get to the heavy stuff, but first, maybe something a little fun. I thought this video was great, so wanted to share this.
You can't touch this. You can't touch this. You can't touch this. Touch this. My coronavirus hits me so hard. All the teachers say, oh my Lord, COVID is stressing me. All the updates from the CDC, Lysol can't be found. I've looked all around this town. I've had no luck, and these are the things that you can't touch. I told you, students, you can't touch this. You better pull that mask up. You can't touch this. It's the CDC, not me. You can't touch this. Hey, go wash your hands. Fresh new rules and plans. Let's all be safe. Go wash your hands. So move back up 6 feet. You better not cough and you better not sneeze. Sanitation. Hold on, let me check your temp. Not under your arm like that. Like that. You're all clear. Go to the back. Everybody says that this is too much, and these are the things that you can't touch. Yo, I told you. Can't touch this. Why are y'all standing so close? Back up. Every time you see me, Dr. Lee is sanitized. I'm gonna keep my hand clean because the cases are on the rise. Now why would I ever stop doing this while others getting ill? I don't want to be sick. I've been to all the classrooms from upstairs into the gym. It's Lee, go Lee, Dr. Lee, yo doc, you're late. Look at the clock, can't touch this. Can't touch this. Break it down. Six feet. Stop. Sanitize.
So you all on this call are now challenged to make similar videos to entertain us with. I thought that was great. Colby told me ahead of time I'm not allowed to dance, so I refrained from my dance.
Yeah, we all appreciate the fact that you refrain from it.
Thank you. Thank you. Okay, so here are some of the topics that we've identified today that we're going to go through. Students wearing masks, obviously that's a changing scenario, right? It's new to everybody. Some special education concerns, some things that have come up with respect to serving special ed students virtually and in person during the COVID pandemic. Also, new Title IX rollout. For whatever reason, this wasn't delayed and went into effect in August, the new Title IX rules and regulations. And so in addition to dealing with returning amongst COVID, we also have a whole host of changes in Title IX, so we'll talk a little bit about that. Talk about employee accommodations. We're seeing a lot of requests for accommodations in the workplace, accommodations to work from home and so forth. And so that's been a big issue. And then of course, employee leave as a result of COVID, right? So either the employee gets COVID or is dealing with a person at home that has COVID. And so that's what we're going to talk about today. That's sort of our general outline. So we'll go ahead and get started. So obviously students wearing masks has been a big issue, right? A lot of school districts are requiring students to wear masks. A lot of school districts have to require that students wear masks, excuse me. And so there's a lot of issues that come along with that. One of those is the request for accommodations. We're seeing this on the rise where a student will come in and say that I have a medical issue that prevents me from wearing a mask in the school environment. And unfortunately, I don't think there's a way to take this out of the sort of framework that already exists with respect to accommodations. I think we handle it the same way that we would in any normal case. And I say normal case when you get an accommodation request in any other scenario, right? An accommodation to either change a rule or requirement because of a medical condition. And there's no difference right now with this, right? If you get a medical accommodation request not to wear a mask, if the student's Section 504 or special ed, I think you have to go through that framework. And unfortunately, that probably means, you know, having a meeting or doing an amendment to the student's plan in order to add that into it. I don't think there's any real way around that. We might have some strategies on an individual basis where we can get out of that framework, but we're still going to have to implement it in the plan. We're still going to have to address it in the plan later. And so I think that's how you need to handle it, is just as you would any other accommodation request, to go through those respective committees. If we're not talking about a student already identified under Section 504 or special ed, the nurse can probably be a good point person to deal with some of these accommodation requests. I think they're equipped to know and understand some of the, you know, the potential conditions that might really impact a student's ability to wear a mask during the day, and be able to push back and ask the doctor relevant questions about the student's need for an accommodation, right? And so for those students, I think we still, you know, I think the nurse is a good person to serve as really that point of contact on those accommodation requests. Again, they can go back and seek some clarification from the doctor if need be, and they're equipped to do that, right? They're trained in medicine a little bit. So one thing to note, though, when you get a request for accommodation, if they're not yet identified, is you have that child find obligation, right? So if a student presents with an accommodation request for a mask and it's a previously unknown condition, that student might qualify under Section 504 or special ed based on whatever information you've gathered. So be mindful of that too. As we see these accommodations come through these accommodation requests come through the door, we might need to, you know, maybe have a 504 meeting to see if any other accommodations are needed in the school environment because of what is a new condition for us. Colby, anything on the accommodations there? Okay. Another request we've seen is requests for religious accommodations. This is a little bit less serious, but I think you still need to go through the steps when you're talking about someone actually asking for an accommodation based on a religious exemption. I think it's important to note that the governor's order does not expressly exempt wearing a mask for sincerely held religious belief. I think that we need to go through that analysis still. We need to determine whether or not there's a sincerely held religious belief and what that religious belief is and why it prevents the active wearing of a mask. And so I think you still need to go through that analysis. Every request that we've seen so far, there hasn't been a lot of sincerity in the request or in the religiously held belief. I think it's the white horse prophecy was cited in one case. And that of course has nothing to do with wearing a mask. It's sort of a religion on the fringes, but based on a Google search, nothing to do with wearing masks. So I don't think that was a sincerely held religious belief, and I don't think it was a valid request, but I still think you need to go through that process if you're presented with a request like that. And then of course, for both requests, right, for accommodation, you can always remind folks that virtual learning remains an option. We've also seen this come up a little bit with masks that have symbols or a message on them. And I think really, again, you're working through your existing framework, right? There's already a dress code. All all the dress codes that I reviewed when talking about this issue all referred to clothing. I think this is an article of clothing, and so all of our standards would apply. And I've got an example of what is defined as clothing and what the restrictions on that are. And I think that, again, this is an article of clothing that applies, and so I think you'd follow your normal dress codes if presented with an issue like this. Interestingly to point out, I think it's interesting to point out, you can ban all statements on masks, right? That's a neutral restriction, just like you could do theoretically for t-shirts and so forth. So if you just banned all messages from all masks, that's something you could obviously do if that's not already in your dress code.
And Andrew, I'll just remind everybody, and I know everyone's probably familiar with this, but the landmark case for First Amendment for students is Tinker versus Des Moines. And I think a lot of people, when they think of the First Amendment issues and clothing, they typically think of t-shirts and things like that. But remember, that case was not based on t-shirts. It was based on armbands, sort of an accessory, sort of the way a mask could be viewed now. And so you're still going to have to look out for those First Amendment issues and make sure your dress code is written in a way that it's not going to cause some sort of viewpoint discrimination or something of that nature. So, we've told clients that if you're not secure in the way your dress code applies to the mask, you can take action at the board level to go ahead and ensure that those are going to be, those dress code provisions are going to be applicable to the mask.
I think that's a good point, especially with the armband. The armbands didn't have a message, right? They were a certain color that had a message. And that's when you get in sort of tricky territory. I think the easier case is when they have a message on them. But if they're a specific color that conveys a message, that's a more difficult set of scenario. Okay, special education has been another huge area where we've seen a lot of questions, a lot of issues pop up. And frankly, a lot of parents just are frustrated with, providing services for their student at home. And as that frustration level increases, as the pandemic continues, I think we're seeing an increase in requests from parents and an increase in frustration with parents. And of course, that leads to conflict. And then someone like me becomes involved. I think that's just sort of natural, right? As parents are trying to do the job of parents and educators, they finally realize that it's difficult to be an educator. And so I think the frustration is rising. So here's some of the issues that have come up, and I'm going to briefly talk about just our obligation under IDEA. Of course, IDEA guarantees students a right to FAPE. This does not change in the pandemic. We are still obligated to serve all students according to their IEPs. There's been no changes at the federal level to our obligation to provide FAPE. But I think it's important to couch that, right? So in reviewing whether or not a school district has provided FAPE, the school district's the court is going to review whether or not the IEP is reasonably calculated to enable a child to make progress that is appropriate in light of the child's circumstances. And this came out of the Andrew F. case a few years back, but I think it's critically important now because as we look at this definition and how the courts analyze FAPE, it says in light of the child's circumstances. And when the court wrote that, they were very much concerned about the child's unique circumstances and their individual circumstances. But I think the pandemic does play into that, right? It's everyone's circumstances at the moment, but it's also that child's circumstances. The circumstances the child has to learn from home or has to learn in a slightly different environment. That is certainly a part of the analysis. And I think courts will agree with that. But while I'm saying this, it's important to note that this hasn't been tested yet, right? The courts haven't said that COVID-19 is one of the child's circumstances. But this is how school lawyers are going to interpret it. And I'm sure the lawyers for parents and for students are going to argue very differently. But I think it's important that schools, are aware of this definition, that this is very much part of the child's circumstances and that FAPE might be different in a pandemic and that's okay, right? Education for all students is different in a pandemic. One thing that I've seen come up a lot is this idea of FAPE light or 0-calorie FAPE or something like that. I don't think that that's really accurate. It's not. It's still FAPE, right? Because FAPE is an education that's reasonably calculated to enable a child to make progress that's appropriate in light of the circumstances. And so we are offering FAPE. It's just that the circumstances are different. And so I think it fits within the definition, and I don't think we need to come up with a term to alter that any. So in providing FAPE, if you can replicate services virtually, and so these 2 points are really talking about delivery of education virtually and some issues that might come up. Obviously, if you can replicate students' IEP virtually, there's going to be no need to make any changes to the IEP. You can simply just do it in a different location, right? So instead of in person, you're delivering the instruction virtually. The issue that comes up is when you can't replicate the exact services virtually, right? And so here's the sort of playbook on how that goes and how we'd like that to go from a legal standpoint. You still need to make an offer of FAPE in accordance with IDEA, right? So you need to develop an IEP that's appropriate for that student and that offers that student FAPE. Now, if parents then say, we want to move to the virtual environment for whatever reason, and the student's IEP can't be replicated virtually, then we need to sort of tailor the instruction, right? But the important part is we need to make sure we offer FAPE initially, right? So we need to make sure that we offer all the parameters of an education that the student needs, and we do that if that's going to be in the physical location. But if parents say, oh, we want to offer virtually, we still need to make that offer, and we need to make that clear. So we've been advising clients is to write that in the IEP and make that expressly that express offer in the IEP, and make it very clear that parents have declined that offer, the offer of that IEP, and would like to educate the child virtually. And then at that point, you move on to a development of an IEP that's appropriate in the virtual environment, right? But it's very important to really make that offer of FAPE in that documentation so that it's very clear that the school district made that offer and that the parents elected to go virtual, which amended our offer of FAPE a little bit because of the parent's choice. It's sort of akin to what we usually do in special ed. We issue a ready, willing, and able letter when a student withdrawals from a district. This is kind of a similar concept where we're saying, look, we're ready, willing, and able to offer FAPE as we've developed in this IEP, and here's the parameters of that. But since you've elected to educate your child virtually, here's our amended offer, right? Here's what that's going to look like in the virtual environment. So again, make sure you're documenting that offer and including that in the paperwork. I think best practice is to include it in the IEP paperwork just so it's clear. Some districts have done a separate notice, and I think that's fine, but I prefer it in the paperwork. At the end of the day, this is sort of our operating framework for FAPE in this environment. Make a good faith effort to deliver FAPE to students, and then document your efforts, and hopefully that'll all be legally defensible at the end of the day. So another issue that's come up has been compensatory education. This has come up for me from the start of the pandemic. I think, in fact, my first request for compensatory ed came 2 weeks into the pandemic. We already had parents asking for compensatory education for services lost during the pandemic. So compensatory education is generally those services that go above and beyond those normally provided to a student in order to remedy a past failure to provide services or implement an IEP. It's a concept that was developed pre-COVID, and it's really meant to sort of compensate for a failure on the part of the district to implement an IEP, deliver a service, or what have you. And it doesn't really fit our current scenario, right? Because it's not that the school district failed to deliver or offer anything, it's that COVID happened and the school district was limited in what it could and couldn't do. And so it's not really a perfect catch-all for our current situation, but we still have to work within that framework. Of course, education of all students has been impacted, right? So that's going to include students with disabilities. The difference here, of course, is because students are guaranteed FAPE under IDEA, we need to make sure that they haven't lost anything, and if they have, that we try to recoup that. And so I think all students with disabilities, when you're coming through the ARD committees this year, I think you need to consider compensatory education and make a finding. And we'll talk a little bit about that. And TEA actually yesterday issued both a webinar and some comprehensive guidance that walks ARD committees through that process and has some questions that you can ask. And so that's a great resource for your folks to have in those ARD meetings, because you're going to have to consider compensatory education for really all students that are special ed. Again, this is sort of a new category. I've seen some states calling these recovery services rather than compensatory education. The idea being that we want to move away from this idea that they're compensatory education, because traditionally that connotes some failure on the part of the district. And we don't have that here, right? This is a sort of a different scenario. TEA hasn't adopted this recovery services moniker, but I think we can go with something like COVID compensatory services. We're doing everything that we would under the compensatory education analysis. But I think if we offer the term COVID compensatory services, it helps us categorize it and say, and point out in our paperwork that, look, this is different from normal compensatory education. And it points to, this is because of COVID. And I think that helps as a moniker, everyone understand that this is different from regular compensatory education. And again, not the fault of the district, but the fault of a global pandemic. So I've sort of counseled folks to go ahead and use that COVID compensatory services and still go through the analysis. And I think that'll help parents, and I think it'll help attorneys and advocates on the other side understand that this is a different comp ed award. It's just a different circumstance altogether, and that comp ed really isn't a perfect moniker for what we're talking about here. So again, keep the concept, follow TEA guidance on comp ed awards, go through that analysis, but I would use something like COVID compensatory services instead of the sort of traditional moniker. So again, our committee will need to address compensatory education for special ed students. That's across the board, right? We're going to need to address whether or not the student needs compensatory education. Again, it could be that the student does not need compensatory education, and that's fine. But we need to have an ARD committee finding of exactly that. Guidance from the Fed says that we need to do this when normal school operations resume. They didn't offer a definition of what normal school operations are. I don't know if we met that definition right now with what's continuing to go on, but I would say that you need to address it this school year, preferably sooner rather than later. But at some time this year, when you're having your ARD committee meetings, you need to discuss compensatory education. As I've seen, parents are likely to initiate these requests. Like I said, I got my first one 2 weeks into the pandemic. At that point, we sort of kicked the can down the road and said, look, school operations haven't resumed completely yet. And I think you can do that in some circumstances, right? Especially if you haven't had a kiddo for a long time, you just get them back, and let's say 2 days in, parents want to request compensatory ed. I think you can say, look, we're not ready to consider that yet. We need to gather some more data on where the student is to determine whether or not they need compensatory ed. And so I think it's fair to have that discussion and to make that finding at this point, especially if you've got some circumstances like, again, not seeing a student for so long and having them for a very short period of time. 1-to-1 minute replication is not required. A lot of times people think that compensatory education means that for every hour or minute of service that I didn't get in my IEP, I now get an award of comp ed of exactly 1 hour or 1 minute, minute to minute, hour to hour to make up for that. And that's not the case, right? It's only to make up for any deficiencies in the student's education during that closure. So again, it's an individualized determination. I think you go to the ARD committee and analyze this, but it's important that folks understand that it's not always a minute to minute or hour to hour award. It's also critical in this comp ed discussion that we consider those students that could not access virtual learning because that sort of put them in the dark for those periods that we were online. Another consideration is parent action. We've seen sometimes that parents, although they had the internet access and although they've worked with their student a little bit, they haven't been maybe on top of the ball on helping us deliver some of the services. And I think it's fair to consider that. Compensatory education is traditionally awarded by either a judge or a hearing officer, and in some cases, of course, the ARD committee. But it's an equitable award, what we call in law. And so that's something where you can consider all the factors, such as a parent's action or inaction in the learning environment. Again, TEA has issued extensive guidance on this that really goes into the weeds. These are just some highlights on these issues. Again, I think every student in special ed, we need to consider comp ed this year. And so again, TEA's got that pretty comprehensive guidance that you can look at, and a new webinar that was issued yesterday. Help walk your districts and your ARD committees through that decision making. One final special ed topic that has come up has been the class action suit. This was a suit that was filed in the Southern District of New York, and it's been filed against every school district in the country. We're not sure if every school district, we're positive that every school district hasn't been properly served, but they've been somehow notified one way or another that this suit is out there. Again, based on our research, it's every school district in the country, and the allegation is that the schools have failed to provide appropriate services during the pandemic. It's a class action suit on both sides, so that means that there's a class action group of plaintiffs and a class action group of defendants. There are a number of procedural requirements for a class action suit of this type, and so this case is going to have to go through significant hurdles in order to get to a point where we're actively involved in litigation. And so I don't think that's likely, but it's something that we can continue to monitor. And it may be a sign of things to come, right? It may be that we see a class action in Texas that is a little bit easier for them to certify a class and can proceed. So it's something to be mindful of. We've been telling folks to notify their carrier about this suit, but look, they already know. Your insurance carriers have gotten these notices. They know that this suit is out there. So again, if you get served with it, I'd notify your carrier, or if you're aware of it, notify your carrier. But again, they really, frankly, already know. Anything on special ed, Colby? I know that's not your bailiwick, but
No, I think covered it pretty well. I think the point you made in the beginning of just doing the best, making a good faith effort, that's what's going to be key. And remember, as we move down sort of away from this time in the school year and everything that's happening with COVID, those suits are gonna last longer than COVID probably will. But what you want is for the judge and or jury to look back and go, okay, they were reasonable in their efforts, to try to give those children the best education that they could at the time. And so, I think as long as you're acting in good faith, you at least have a little bit of a legal defense there for the future.
And really, that's the key to all special ed disputes is making your good faith effort and documenting. Hearing officers, that's basically what they're going to look for in any review, not just during COVID. So anyway. All right, Title IX rollout. Just to make things more difficult for you all, there are new Title IX regulations, and they went into effect August 14th. So that means some significant changes to how we handle Title IX complaints and how Title IX is investigated. And yeah, just sort of adds to the party that is the start of the school year. So Title IX obviously is an anti-discrimination law. It prohibits discrimination on the basis of sex in education programs and activities that receive federal funds. The new regulations make some changes to the definition of sexual harassment. I'm not going to go through all that here, just again, 30,000 foot view about sort of some of the issues that you need to be aware of. It's a pretty comprehensive law, and these changes especially have made it, I think, even more comprehensive and have sort of raised the bar on expectations for school districts. Of course, this is a law that's enforced just like most laws through lawsuits, but also through the Office of Civil Rights. And so an OCR complaint is still possible. So again, these regulations went into effect August 14th. There were numerous injunctions that tried to stop the implementation on August 14th. Those haven't gone through just yet, but it's already happened. They're already in place. And so we are expected to follow these Title IX regulations as of today, right? So some of the changes, the investigation process, they've made a complete overhaul on how we handle Title IX complaints. And I'll walk through a little bit of that, but it's basically changed top to bottom. So your new board policy FFH will reflect those changes. That's an update, I think 115 from TASB. and you'll notice it right away, the amount of changes to the investigation process. There are also some definitions of standards that have changed. They've added some legal standards to help make decisions along the way. There are new training and posting requirements that went into effect. The role of the Title IX coordinator has been completely overhauled, and we'll talk a little bit about that and some issues that might stem from that. There's some new roles that need to be designated in addition to your Title IX coordinator. You've got advisors, decision makers, folks like that need to be designated. And they've also added notice sexual harassment in the regulations, which wasn't there before, which is that if any employee has notice of sexual harassment, then the school district is sort of on notice of that sexual harassment and has to initiate an investigation and go through the Title IX process. Again, complete overhaul of the investigation process. I saw TASB put out, again, in their 115, some changes to their board policy, but they've also put out some forms that can help walk you through investigation process. I know Underwood has done the same thing. We've got some forms and flow charts that help walk through the investigation process and exactly what happens when, what happens on each occasion. It's even color coded, so there's that. Again, don't need a complaint. Notice is enough, right? So if one employee has notice of sexual harassment or any violation of Title IX, then we have to go through the process. And so that's really an obligation on the districts to make sure that our folks are trained to recognize that and are trained to report that to the Title IX coordinator so that it can be handled appropriately. Another important aspect that's changed under these regulations is that we must treat complainants and respondents equitably. There's been a huge emphasis on ensuring that just because an accusation is made, that that no action is taken until there's a finding that that person has actually engaged in a violation of Title IX, right? They've put a lot of emphasis on ensuring that they're sort of innocent until proven guilty, right? And that's sort of a legal term and something out of criminal law. That's really what they've tried to do throughout this change, throughout this overhaul, is to make it so that they have to go through all these steps before we take any action against what's called the respondent. And that's really the alleged aggressor or the alleged person who's engaged in the Title IX violation. And so they really have this presumption of innocence that they didn't necessarily have before. And so you need to be cautious as you're going through your process that we don't take any action until there's a finding that sexual harassment has occurred or that any other violation of Title IX has occurred. Again, the process completely changed and involves numerous new people in the process. Title IX coordinators, of course, still there. You have advisors, which could be brought in. The investigators and decision makers are also given different monikers instead of that all being within the Title IX. The Title IX coordinator can also be your investigator, but they can't be the decision maker. And so it's important to break out those two roles. And so we'll talk about in a minute that typically when a superintendent is named as a Title IX coordinator, that might not work anymore under this new paradigm. It's probably better for the superintendent to serve as that decision maker rather than the Title IX coordinator, so that we have sort of a separation of the decision maker and the Title IX coordinator, and also it fits into our framework where the superintendent can make the decision, and then that's appealed to the Board of Trustees within our FNG policy. Another change is that the Title IX coordinator can implement the complaint process, a formal complaint process, even without the victim giving consent to that. They can start there's two processes. One is the informal and then the formal. Title IX coordinator can initiate that formal process even without really cooperation from the alleged victim. Again, the Title IX, even the regulations say that superintendent is probably not the best person to serve as a Title IX coordinator. You probably want an administrator in that role, just so that they have the ability to do all the things that a Title IX coordinator needs to do. But again, a superintendent is probably not that person. They must be known as a Title IX coordinator, and that notice must be given to parents and employees. So obviously this is already in policy, but it should be in policy with your new person if there's a new person, or to make sure that the information is accurate. We recommend putting this in posters, handbooks, that's employee and student handbooks, websites, and of course, employee application materials. Put it everywhere you can. Make sure that the Title IX coordinator is readily accessible and everyone's aware of the Title IX coordinator. The regulations require training for all on Title IX, and the training must be posted on the website. We got a lot of panic on August 14th, the day the regulations went into effect, that say that you had to have the, do we have to have the training on the website on that day? I think the answer to that question is no. The regulations went into effect on August 14th. I think you need to move towards posting that training, to getting the training done and to posting the training. But I don't think that had to be on your website by August 14th. I think you need to move towards doing that, but that it didn't have to happen as a hard deadline there. Anything on Title IX there, Colby? Okay. So employee accommodation requests. We've seen a lot of these pop up, especially as we're moving to in-person. A lot of employees want to continue to work from home. So they present with a request for an accommodation. Again, there's an existing framework for all this. It's just a little bit modified on COVID. Need to go through the ADA framework and discuss, when presented with this request, what we can do in the workplace that might accommodate that employee, right? We're already doing a lot. There's a lot that TEA has outlined with respect to keeping kids and staff safe, but we still have to have this discussion, because we still need to see, is there anything additional that we could do to help protect this employee based on whatever information they provide about their medical condition, right? So if they come in and they say, I have a medical condition, and so I'm particularly susceptible to COVID, and so I want to work from home, and if that's not possible, we need to work through the accommodations to the workplace that might allow that employee to come to school. Again, you're gonna have to discuss this with the employee and work through that analysis. What I want to make sure that folks do is they document the things you're already doing to accommodate for COVID, because you need to take credit for all these actions that are different. And also, I think that needs to be communicated to the doctor. The doctor that writes a note and says the person can't work or can't be in close contact with students or what have you, they might not understand all of the steps that we're already taking in this COVID world. And so when presented with that information, that might help their analysis in determining whether or not it's safe for the employee to come back. So I think you need to discuss what you're already doing, that TEA is outlined, or that you're going above and beyond TEA to sanitize, to keep folks separate. All of that needs to be communicated to the doctor and to the employee and documented. And then if that doesn't help the situation, the employee still feels like they need to work from home, then what additional accommodations can we offer? I've got an example here: allow frequent breaks to wash hands, right? That's a targeted request for a specific employee. So what if the employee does not agree to accommodations? I think you communicate with the doctor all of your offers of the accommodations, and again, both the general accommodations and the workplace accommodations you're offering for that specific employee, and then ask that they fill out a not fit for duty form once the employee has rejected all of those accommodations or offered accommodations. And then, of course, consider leave, which we'll talk about in a little bit, if the employee really can't work with any accommodations. Colby, anything on accommodations?
No, just like any employment situation, everything's about the documentation. And so you're going through those accommodation requests and discussions. Make sure that you're documenting everything appropriately, that you're having them look at their job description, that you're trying to meet the accommodations. And at the end of the day, if the doctors are not going to let up, and that's the note that we have, or the form that we have that says they can't come back to work, you're going to be stuck to a certain extent. But obviously we want to accommodate and have everyone come back to work, but in some cases that just may not be possible.
Okay, so one of the biggest changes has been employee leave. There's been some new really additions to leave availability for employees, especially with respect to COVID. We get a lot of questions about this, and this is just bound to increase as we sort of exposures are on the rise and as more folks are requesting leave because of COVID-related exposure. So we're going to walk through some of the changes and some of the additions. Here's sort of the general framework. Of course, the ADA still applies. We talked about that already, accommodating employees. The Family Medical Leave Act still applies. We'll walk through that. And then the addition here is the Families First Coronavirus Response Act. And this added two new leave provisions that allow employees for additional leave because of COVID. So I'll walk through that pretty quickly. So FMLA, this has been in place for a while. It's already in board policy. It's been a law for some time. It allows an eligible employee to get up to 12 weeks of unpaid leave for the reasons listed here, and I won't go into that. But there's no changes to this. This is still available for all employees. It's important to note that FMLA runs concurrently with all other leave, right? As long as that's outlined in your policy, which it probably is. So be mindful that those employees that are out because of a COVID-related reason, FMLA still applies to them, in addition to what we'll talk about in the Coronavirus Act. So this is the FFCRA, and it added two new monikers, EPSL and EFML, emergency paid sick leave, and then expanded family and medical leave. And we have a handy dandy chart we'll get to that walks through all that, but just know that the FFCRA added two new leave provisions. So for purposes of EPSL, all employees of eligible employees are eligible employers are eligible for 2 weeks of paid sick time for specified reasons related to COVID-19. Again, we'll walk through what those are. That's 2 weeks of paid sick time for EPSL, which is 10 days, right? Employees that are employed for at least 30 days are also eligible for an additional 10 weeks of EFML, which allows for leave to take care of a child under certain circumstances related to COVID-19. Really, it's about availability of the child's child care, right? And if that person doesn't have availability of child care, then they might qualify for EFML. And that's for 2/3 of the employee's regular rate of pay. So again, EPSL, you are eligible on the first day of employment. So all employees are eligible immediately, and this is available regardless of whether they can't work because of in-person or remotely. Basically, if they can't work, then they're entitled to this leave. Okay, we may not require that employees use accrued leave instead of EPSL, but they can do so. This is completely on employee's election. They can use either their local leave or EPSL, but they only get this once, right? So they get these 2 weeks and that's it. So it's really up to the employee if they get sick with COVID-related issue. It sounds like you can get sick twice from COVID, we're learning. And so, it's really up to the employee how they want to use it, but they just get this EPSL once. So, it's important for them to consider that as they wish. Importantly, if allowed by the employer, you can use EPSL and a portion of accrued leave to receive 100% pay. And we'll talk, I think, a little bit about that further in a few minutes. These are the qualifying reasons for the EPSL. Employee is subject to a federal, state, or local quarantine order. The employee has been advised by a healthcare provider to self-quarantine. Employee is experiencing symptoms of COVID-19. Employee is caring for an individual subject to reasons 1 or 2. Employee is caring for his or her child, or the employee is experiencing substantially similar health condition as defined by HHS. One of the interesting things that we've seen come up for number 1 is employee is subject to a federal, state, or local quarantine order. In the FFCRA, Congress was very specific, or I guess I should say careful in their wording. They didn't say local health authority order. It just says from a local authority. And that could be, I think, interpreted to mean a district saying that you have to self-quarantine because of a particular reason. And so, anyway, Colby, you have anything to add to that? I know that's been an issue we've talked about a lot.
Yeah, no, it would have been helpful if they would have been a little more specific with that to give us some guidance, but unfortunately, that's just the nature of the beast.
Guys, we have a question. How long does EPSL last? Is it only for 1920?
Yeah, that's a good question. As of right now, my understanding is that it lasts for, unless you use it, it's just for this year. But I have to go back and look at the regs. Colby, are you aware of the time frame on it?
Yeah, I mean, my understanding is that it's over at the close of this calendar year.
I thought so too, but I have to go back and look to be sure. So for part-time employees, with a standard schedule, they can receive the number of hours worked in a typical 2-week period. Those with a varying schedule receive an amount of hours based on a 6-month sort of snippet from the date leave is first taken. Again, for those for part-time employees. So EFML is that second period of leave offered for employees. And that provides that up to 12 weeks of family medical leave if the employee is caring for his or her child because of the child's school or place of care has been closed or is unavailable due to COVID-19 precautions. Again, this area is sort of left vague by the regulations and has been left open to interpretations. Place of care, for example, not defined, and so there's likely to be some disputes about whether or not, for example, a grandmother watching kids that's not available qualifies there. We're likely to see some pushback on that. Again, I think if the child's care is unavailable, they likely qualify regardless of where that care came from. Again, closed school facility providing online instruction may serve as a qualifying reason, so keep that in mind. And again, these employees are eligible for this after about 30 days of employment. Anything on that, Colby? Move past these here. So two-thirds of employee pay, up to $200 daily. The first 2 weeks of EFML are unpaid. The reason for that is to sort of overlap with EPSL, right? You can use local leave, of course, too, but I think was the intention originally, was that EPSL would serve as that first 2-week cover, and then this extended leave would then kick in. But yeah, basically the first 2 weeks are unpaid, and you qualify for that. Most districts require temporary disability leave and paid leave, including comp time, to be used concurrently with FML, but you'd have to consult your DEC local for that. This is, I think, a really helpful chart that outlines basically everything we talked about and the leave provisions. You notice the first 3, you qualify for EPSL at 100%, and then 4 through 6 qualify for two-thirds for EPSL, and then number 5 is that one that gets you both EPSL and EFML. So it walks you through all of the qualifying reasons there. Anything to point out on this, Colby?
I don't think so. I think this is a great cheat sheet, for HR folks that are out there and looking for something quick and easy.
Yeah, I agree. It's on my desk anyway, so. All right, some documentation I want to go through real quick. I don't have too much time. Some of the documentation we're going to require for use of these new sort of leave provisions. The reason for leave, the statement that the employee is unable to work because of a qualifying reason. If you're talking about a quarantine order or something like that, we want to see that order. We want to confirm that order exists and document that. Again, make sure that that's folded into our documentation. And then, of course, if it's a healthcare worker that has said that the person needs to quarantine, we need information related to that, right? The documentation that specifies exactly what that looks like. Okay, what employee documentation may be required? When the employee requests leave to care for a child whose school or place of care is closed, information about the child, name of the school, place of care, child care provider that is closed. I want to make sure we document that to ensure that that's actually a legitimate use of leave. Again, we want to make sure we push back and make sure that the employees are actually documenting all of this, because I think, and Colby and I have talked about this, some of these leave provisions could be sort of an opportunity for fraud, right? For employees to say that my child care place, my child care facility is closed when in fact it isn't. And I think we've already seen some of that occur. So it's important that we require documentation of that, and so that we can hold the employee accountable in the future if necessary. Anything there, Colby, on documentation? And TASB has some helpful forms, I think, for some of this that you might look at. But again, make sure that you're just documenting all the actions and all the requests. I think I stuck the landing there at 12:25.
You did.
Any questions, we're happy to answer them, but I appreciate y'all taking the time, and hope this was helpful in some way.
Perfect timing, Andrew. We appreciate it. We do have a few questions in the chat, and I will just go ahead and add that we've recorded those, and we'll make sure that we get those answered. We've run out of time for those today, but thank you both, Andrew and Colby, for joining us. That was great information, I know, for a lot of people. In the last little bit of our call, I'm going to turn it over to Jill Schott with the College Board, and she has some great information and resources to share with us before we close. So Jill, I'll turn it over to you. Oh, I think you're still on mute, Jill.
Sorry, can you see my screen?
Yes, we can.
Okay, I had 1 out of 2. You'd think by 5 months in to have all this down, but that was really interesting, guys. I'm glad that I sat through that. That was fascinating. So many different things with the laws. We've got changes with assessment as well. I assume most of the folks on the call today are familiar with PSAT and MSQT. About 90% of Texas public school students do take PSAT by the time they're juniors. So this is on most people's minds. We have 2 administrations every year. So those 2 October tests are still available, but just this week we have announced we're adding a 3rd opportunity to offer the PSAT and MSQT. It's a paper pencil test that you have to give in person. So we just wanted to give that one more shot in case there was an interruption in face-to-face instruction that made October not such a good fit. You could actually give the test all 3 times, just not to the same kid. Each kid can only take it once, but a school can offer all 3 to make sure the maximum number of students have the opportunity to participate in this important college readiness activity. But that's a brand new, hot off the presses announcement, January PSAT for this school year only. Advanced placement, I know is a big challenge where we have students learning in a variety of different modes, some of them in class, some of them at home all the time, and some of them in sort of a hybrid mode. We are providing extensive online resources at no cost, and we hope that that provides some flexibility. And you know, we've got our unit guides. Our daily videos are the main thing I wanted to highlight. Those are brand new. They'll launch on September 1st, so just next week. You can start seeing those. Every AP course will have videos for every topic within our course and exam description. Certainly doesn't replace the high quality teachers that you have out in the field, but it's nice for students to just be able to hear another person explain it, for the teacher to use that as a supplement, just to reinforce the skills and knowledge that have been covered in the AP class. So that is a big new thing to highlight. I hope your teachers will use it. Spread the word about AP daily videos. But we've got support for every step of the instructional process, from planning through assessing, through giving feedback, and those all can be used at home, in school, or in hybrid mode. Important deadline, November 13th. We do have a fall ordering deadline again this year for AP. So that's a big one to get, because you don't want to have late order fees. But the good news is there's no risk because we don't have any cancellation fees this year. So it would be my recommendation that just order an exam for everybody who's in AP. If they end up not taking it, you aren't going to have the unused test fee. So that's probably the safer bet, because if they decide late, then there would be the $40 late order fee. But we know that students are in a variety of different situations, things can change. So we just wanted to take that stress off of them and remove any kind of unused test fee, cancellation fee, so they can just sign up and then make up their mind later if they need to change. So those are the highlights I wanted to hit for you. It looks like we're right at 12:30 based on my clock. So give it back to Kate.
Thank you so much, Jill. Thanks again for joining us, and to College Board, as always, for their support of the Fast Growth Schools Coalition, as well as public schools all across Texas. So thank you so much for being here and for these resources. We have dropped some of the resources that Jill shared with us into the chat. We will also be following up with those via multiple platforms, so please watch for those. Thank you again to Andrew and to Colby and Underwood Law for being here today. And please watch for additional webinars and lunch and learns in the future. We look forward to announcing a lot of those and the content that will be associated with those very soon. Happy Friday, everyone, and we'll see you soon.